Hello, everyone, and welcome to Insights on Law. So, today we are going to understand how to draft a condonation of delay application. So, basically, what do we mean by condonation of delay? So, if you have been reading the Limitation Act, the Act provides for specific time period for filing of appeals or application before the court, and these appeals or applications have to be filed within a specific time period which is provided in the Limitation Act or in the specific acts. And if suppose the case is not filed within the set time limit, then an application is filed before the court to ask for condoning the delay. Basically, the court allows the delay in case of any sufficient cause is shown that why the particular case could not be filed in the given amount of time. So, this is an application by which the court has the power to let the party file the case even after it is filed after the limitation period. So, today we will see how to draft a condonation of delay application, for which we have certain facts of the case. Now, this has been made by me so that I can explain how to draft the condonation of delay application, and this is imaginary facts which I have prepared only for this video. So let's get on to it. So, coming to the facts of the case, the facts say that in this case, A had filed an application for maintenance under Section 125 of Criminal Procedure Code 1973 before the Learned Magistrate Court, Mumbai, against B. After an order dated 5th January 2025, the learned magistrate dismissed the application for maintenance, observing that A was gainfully employed and capable of maintaining herself. Being aggrieved by the said order, A intended to file a criminal revision application under Section 397 of the CRPC. Now this section has become Section 438 of BNSS before the Honorable Sessions Court, Mumbai. However, due to certain unavoidable circumstances, the revision could not be filed within the prescribed period of limitation of 90 days. Now, where this 90 days is mentioned, I am going to show you later. Immediately after the pronouncement of the impugned order is basically the 5th January 2025 order. A underwent minor surgery and was advised bed rest for 3 months by her doctor. During the same period, her advocate's office was shifted to a new location, leading to temporary misplacement of case documents. So, this is the reason why the criminal revision application could not be filed within time, because first thing that A was advised bed rest for 3 months by her doctor, and secondly her advocate's office also shifted to a new location, because of which the papers could not be located in time. So, owing to these circumstances, the revision petition was filed on 10th May 2025, resulting in a delay of 35 days in filing. Now, A wishes to file a condonation of delay application. Just a second. A wishes to file a condonation of delay application under Section 5 of the Limitation Act 1963, explaining the reasons for delay and seeking permission of the Honorable Court to admit the criminal revision application. So, what has happened from the facts we understand is that A had filed an application for maintenance under Section 125 of CRPC before the Magistrate Court. That got rejected. Now, to challenge that order, A has to file a revision. Now, this revision had to be filed within 90 days from the order of the magistrate court. However, A could not file the revision in 90 days because she was advised bed rest for 3 months and her advocate's office changed, because of which the papers could not be located and the papers were misplaced. This is why A, instead of filing the application within the limitation period, could file the criminal revision application only on 10th May 2025, which has caused a delay of 35 days in filing. So because the application is filed after 35 days of the limitation period, we need to first file a condonation of delay application asking the court to allow us to file the criminal revision application and condone the delay of 35 days. Okay, so to do this, we need to see certain relevant sections that are applicable in our case. First section is section 397 of the CRPC. This is the section for revision, right? Now this has been replaced with section 438 of BNSS, right? Next is section 5 of the Limitation Act. Now what does section 5 of the Limitation Act say? It says regarding extension of prescribed period in certain cases. Extension of what? It is the extension of the limitation period which is prescribed in law. So any appeal or any application other than an application under any of the provisions of Order 21 of Code of Civil Procedure 1908 may be admitted after the prescribed period if the appellant or the applicant satisfies the court that he had sufficient cause. This word sufficient cause is very, very important for not preferring the appeal or making the application within such period. So if any appeal or if any application for which there is a prescribed time and that appeal or that application could not be filed in that prescribed time, what can the court do? The court can allow that person to file the particular appeal or application even after the prescribed time if sufficient cause for not preferring the appeal or making the application within such period is shown. Sufficient cause is basically the cause that the court thinks is sufficient for the applicant or the appellant to not file the case within the prescribed time. Okay, now coming to the point of what is the prescribed time for filing a revision. So Article 131 of the Schedule of the Limitation Act talks about the limitation period for filing of revision. So it says, to any court for the exercise of its powers of revision under the Code of Civil Procedure or the Code of Criminal Procedure, which has now become BNSS, the period for limitation is 90 days. So the period of limitation for filing revision application under the CRPC is 90 days. The limitation period starts from the date of the decree or order or sentence sought to be revised. So when does the limitation period start? It starts from the date of the decree or the order or sentence. So in our case, the limitation period will start from 5th January 2025 and would end after the period of 90 days. Alright, and if the revision is filed after 90 days, then a condonation of delay application has to be filed. Alright, So let's see how we need to draft the condonation of delay application. So this is the draft that we will understand how to make. So for any draft that we are making, I have a particular structure that I follow. Is that first we introduce the facts, or first we give an introduction of what this application is all about. Okay. Then we move to the facts of the case. Then we move to the legal point, basically the grounds on which we are filing the application. And then finally we move on to the prayer. Okay. So now, because this is an order which is passed by the magistrate court, we will file the revision in the higher court, which is the sessions court. So we are going to file this revision in the sessions court at Mumbai. Criminal miscellaneous application number so and so of 2025 in criminal revision application number so and so of 2025. So this can vary, the nomenclature of the application may vary depending on the jurisdiction, but mostly this is how the application is named. So A versus B, because you're filing an application, it will be the person filing will be an applicant and respondent will be the other side. We mentioned that this is an application for condonation of delay under Section 5 of the Limitation Act 1963. We just seen Section 5, right, which talks about the power of the court to condone the delay if the application or revision, if the appeal or application is filed after the prescribed time period. Most respectfully, Shovit. Introduction. So now we are going to introduce that why this particular application is being filed. So it says that the applicant has filed the captioned application seeking condonation of delay in filing the criminal revision application against the order passed by the learned magistrate rejecting the maintenance to the applicant under section 125 of the Code of Criminal Procedure 1973. So this sums up what your entire application is. This is what I like to do in any of my drafts. So first para just gives a summary of what this entire application is about, right? Then we go on to introducing the parties. The applicant is the legally wedded wife of the respondent. Okay, we've introduced who the applicant is and how she is related to the respondent. The respondent is a businessman by profession and has abandoned the applicant since last 1 year. So this explains why the applicant has filed this maintenance application in the first place. Okay, so first the summary of what the application is about. So the judge only has to read the first para and he'll understand what this entire application is going to be. Second is we introduce the parties. Who the parties are, who is the applicant, who is the respondent, that we have done in the second para. Now we'll come to the facts of the case. So the facts of the case, the applicant had preferred an application under section 125 of Code of Criminal Procedure 1973 seeking maintenance from the respondent before the learned magistrate court Mumbai. The learned magistrate by order dated 5th January 2025 dismissed the applicant's maintenance application, holding that the applicant was capable of maintaining herself. Being aggrieved by the said order, the applicant intended to prefer a criminal revision application under section 397, now it's 438 of BNSS, before this honorable court. However, due to reasons beyond her control, the said revision could not be filed within the statutory period of limitation of 90 days. Where does this 90 days period come from? It comes from the Article 131 of the Schedule of the Limitation Act, which mention about the limitation period to file revision. Immediately after the pronouncement of the impugned order, the applicant had to undergo a minor surgery and was advised bed rest for 3 months. The applicant The applicant was thus unable to coordinate with her advocate or arrange for filing of the revision in time. So here what we can do is that we can also attach. So we can just mention here that here to attached and marked as exhibit A is the copy of the applicant's medical documents, or if there is any certificate from the doctor, we can attach that, so it helps our case. Okay. The applicant was thus unable to coordinate with her advocates or arrange for filing of the revision in time. Okay. So once you add these documents, it is going to substantiate your case. Then further, during the said period, the office of the applicant's advocate was relocated and the case papers were temporarily misplaced in the process of shifting, which caused an additional delay in preparation of the revision papers. So for this, what you can do is you can also take an affidavit of your lawyer stating this fact. It is not compulsory, but if you can, it is better. If you can't, the advocate can orally also persuade the judge saying that this had happened, so I could not file it in time, and hence the delay. Owing to the aforesaid genuine and unavoidable circumstances, the criminal revision application could be filed only on 10th May 2025, resulting in a delay of 35 days in filing the same. So these are our facts. Okay, we've stated everything what we had to state. We've stated what happened in the lower court, why we could not file the revision in time, what was the reason for the delay, when did we file it, how many days of delay is it, everything has been mentioned. Now we'll come to the legal part of it. We will talk about the grounds. So grounds are very important because based on these arguments, the court would decide that why this application has to be allowed. Okay. So the reasons why this application has to be allowed is the grounds. So that under Section 5 of the Limitation Act 1963, this Honorable Court has discretion to condone delay where sufficient cause is shown. So we are telling the court that the court has this power and the court has the discretion to condone the delay if sufficient cause is shown. Then, that the applicant's medical treatment and subsequent recovery period constitutes sufficient cause within the meaning of Section 5. So we are saying that what reason we are mentioning is sufficient cause within the meaning of Section 5, and hence because I have shown sufficient cause, hence this court should exercise its discretion under Section 5 of the Limitation Act. We are making this argument before the court. The delay caused in filing the revision is neither deliberate nor intentional but occurred due to bona fide and unavoidable circumstances as stated herein above. So if you read judgments on condonation of delay, you will understand that what the judges are looking for is that the reason has to be bona fide and not intentional. You cannot sleep over your rights. Okay, you cannot sleep over your rights and then come one day and say that, oh, I could not do this in time, today I have got time, I will do it. The reasons why you could not come in time have to be not intentional. They do not have to be deliberate. They have to be bona fide and unavoidable circumstances. That the applicant has acted diligently and has filed the revision application immediately on recovery and retrieval of papers. We are trying to make our defense as strong as possible. That no prejudice will be caused to the respondent if the delay is condoned, whereas the applicant will suffer irreparable loss if the matter is rejected on technical grounds, which is a very, very important argument. The respondent is benefited if this condonation of delay application is not allowed. So, no prejudice will be caused to him if the delay is condoned, but it will cause a lot of loss to me because my right of getting maintenance would be rejected on a technical ground, not on merits. My application is not decided because until and unless the delay is condoned, my application cannot be decided. So, my application is not decided on merits but on technical grounds. I don't get an opportunity to challenge the order on merits. Next, it is a settled law that while considering an application for condonation of delay, a liberal and just approach should be adopted, and that sufficient cause must be construed in a manner that serves substantial justice between the parties. So, these arguments you will get from judgments. Okay, judgments explain that when the court has to exercise its discretion, okay, a liberal and a just approach must be taken because layman may not understand the importance of limitation period. Sometimes the delay is very genuine, and in this case the courts have to take a liberal or a just approach before deciding the sufficient cause in any matter. Then you can see that we've cited one judgment. Now, citing of judgments in your draft is not the rule per se, but it has been a practice that we cite few landmark judgments so that when the judge reads your application, they understand that this is the law, and you can always substantiate those judgments with the latest judgments in your arguments. However, citing of judgments in your draft is not the rule, but by practice it is being cited and it helps basically to create a groundwork for your oral arguments, and you can substantiate those judgments with latest judgments or any other landmark judgments by way of compilation of judgments that you can give during the arguments. So we've cited one judgment here. The Honorable Supreme Court in the case of Shior Raj Singh versus Union of India has observed that where the delay is explained and is found to be satisfactory and acceptable, the delay can be condoned. Okay, so it lays down the criteria for allowing condonation of delay. Because if you see the section is a very small explanation as to what can be done in case the applications or appeals are not filed within the prescribed period. It just talks about sufficient cause, but what is sufficient cause, how it has to be dealt with, that is basically explained in judgments. In the present case, the applicant has provided a satisfactory explanation and sufficient cause for condoning the delay. The relevant portion of the judgment is reproduced below. What the judgment says. So in the judgments also, the part that you know would help your case, you can highlight those portions. So if you see what the judgment says, considering the aforesaid decisions, there cannot be any quarrel that this court has stepped in to ensure that substantive rights of private parties and the state are not defeated at the threshold simply due to technical considerations of delay. So this judgment helps me because the court itself is saying that based on technical delays, the substantive rights of the party should not be affected. However, these decisions notwithstanding, we reiterate that condonation of delay being a discretionary power available to the courts, exercise of discretion must be necessarily dependent upon the sufficiency of the cause shown and the degree of acceptability of the explanation, the length of delay being immaterial. So what the court here said is that the length of the delay does not matter. What matters is the sufficient cause why the delay was made. So this basically explains the criteria for allowing an application for condonation of delay. Then we add the standard paragraphs. The applicant craves leave to rely upon such other grounds, facts, and documents as may be necessary at the time of hearing. At the time of hearing, you may come up with more grounds or maybe some substantial facts, later facts, or documents which may help you during the hearing. So, if suppose you could not get the medical documents while filing this application, you can submit the medical application during the hearing. So we crave leave. We tell the court that please give us permission. I am seeking this permission right now only to produce these documents at the time of hearing. Then, in view of the above, the applicant most respectfully prays that this honorable court may be pleased to. So now we come to the final and the prayer clause, where we are asking the court to condone our delay. So, first prayer is condone the delay of 35 days caused in filing the criminal revision application against the order dated 5th January 2025 passed by the learned magistrate, and pass such further or other orders as this honorable court may deem fit and proper in the interest of justice. So this is our main prayer. This is the prayer that you're going to add in all your applications. And finally, place, date, applicant sign, advocate sign. This is how the entire application is made. This can be followed by a verification clause and affidavit in support if this is required in your jurisdiction. Verification clause can be added. When I'm explaining more drafts in future, I will include the verification clause. In this draft, I have not included it yet. But yes, this was how a condonation of delay application is drafted. I've shown you the structure. I've shown you what all essential elements are to be added in the draft, what section, what law, what judgment. I think this has been a detailed explanation of how a condonation of delay application is drafted. I hope you find this video helpful, and in case you like the video, please share it with your friends, like and subscribe to our channel. Thank you.